I'm Vijaya in conversation with the immigration attorneys of the NPZ Law Group serving immigrants and employers throughout the US, Canada, and around the world. David Nachman, founder and managing attorney at NPZ Law, is back with me. Welcome, David, and I have a question for you on H-1B Portability. What is it and how does it work?
Well, it's a great question, Vijay, and one that we get frequently because a lot of people want to start in new positions of employment on their H-1Bs. So basically, this is the scenario. What happens is an individual, and as you are probably aware from other of our discussions and programs, that the H-1B begins on the beginning of the fiscal year, which is October 1st. And individuals, they start their jobs on the H-1Bs, and sometimes there's trouble in paradise. And it may not even be trouble in paradise. It might also be that the individual wants to move on. It might be that the individual receives, because all of a sudden they realize that their skill sets are highly coveted. They get opportunities that are offered to them. And so what essentially has happened under AC 21, and this is, by the way, Section 105C of AC 21, and it provides for what's called job portability, not to be confused with mobility, which is under Section 106C. And Section 105 is portability. So what does it mean? It means that an individual can take up a new position as long as they are on a valid H-1B, okay, and all their H-1B criteria have been satisfied. They can move to a new employment position upon the proper filing of an H-1B. So what it does is it sort of unshackles the individual so that they're not tied necessarily to that prior employment position, but they can actually move to the new employment position upon the proper filing. So we have to sort of unpack what proper filing means, because that means different things to different organizations. So for example, one organization that we work with considers a proper filing to be that when the FedEx is delivered to the USCIS, that would be considered a proper filing. Another organization that we work with considers having the receipt notice from the USCIS to be the proper filing. And then we have another organization that's even more conservative, and they want to have the approval. So the approval happens, though, unfortunately, it could take many weeks before you get an approval on an H-1B. And that's a bit of a problem, because then, the individual has to wait before they can onboard that person. So there is what's called premium processing. So oftentimes what you'll do is you'll couple maybe the idea of using portability with using premium processing to advance the cause. But the idea here, and I think the underlying premise under the AC 21 philosophically, was to allow for free market movement of these individuals who have such high skills, and to allow them to be able to move to organizations that are willing to offer them better wages, if they can, better wages for the skill sets that they possess. So that's what AC 21 provides on portability. And it's it's a really nice tool. Depends upon really the corporation's desire to be aggressive or not, whether they want to be aggressive. I think one of the other things that we oftentimes take into account when we advise employers is that there is a potential issue with regard to a conflict. So we do have conflict waivers signed, and also indemnification agreements, because if the company decides to use the portability provision, you have to play it out. What happens if the H-1B is denied? Because oftentimes the individual has already moved to the new place of employment, and then if the portability is denied, if the case is denied, then where do they go? Because they can't go back to the old place, and they probably can't stay with the new place. So
between the devil and the deep sea.
Yeah, exactly. But what we do is we are able to help the employers to navigate that potential gray area, and we've done that in the past. But again, portability is a nice tool. Definitely something, however, that should be explored with legal counsel if an employer is planning to use it.
Well, again, thank you so much, David, for bringing that to us, and to know that there is, they're free from the shackles for a bit, and there's this possibility of portability. So thank you for that, as always. And of course, it's time to thank all the attorneys, Attorney Gaganjot Mundra, Lud Kazimovchik, Samantha Oberstein, and of course, David Nachman of the NPZ Law Group for making complex US and Canadian immigration law issues so simple to understand. They're just a phone call away. Call them today at 201-670-0006 or simply log on to visaserve.com. I'm Vijaya. Join us every other Wednesday, 4 to 5 p.m. for more enlightening insights on immigration from the NPZ Law Group. For now, stay tuned to Mirchi. It's hot.